According to plaintiffs, Starbucks made a conscious decision to underfill lattes when faced with financial difficulties and high milk prices at the end of 2007. Defendant moves for summary judgment on the grounds that plaintiff cannot prove a false statement or representation based on the undisputed facts. And then here we have, out of the Northern District of California, the Sierra Strumlauf lawsuit against Starbucks Corporation. The plaintiffs bring this putative class action against defendant Starbucks, alleging that defendant uniformly underfills its lattes and mochas. Plaintiffs allege 8 causes of action: breach of warranty, violation of various consumer laws, etc. Now before the court is defendant's motion for summary judgment as to all claims. Also before the court is plaintiff's motion to strike paragraphs 13 to 15 of a declaration of Deborah Antonio and paragraphs 4 to 5 of Wendy Luban. Having carefully considered the pleadings and fully briefed motions, the hearing held November 7th and December 19th, and for the reasons set below, the court denies plaintiff's motions and grants defendant's motions. So that's entirety. That's granting summary judgment in its entirety. Background. Starbucks is a Washington corporation with its principal place of business in Seattle. Starbucks operates over 23,000 retail locations worldwide. Plaintiffs are consumers who purchased lattes at various Starbucks retail locations in the United States. Lattes are hot beverages created by mixing steamed milk with espresso, which are then topped with a thin layer of milk foam. Starbucks gives customers the options of specifying the type of milk, how much they want in their latte. Starbucks retail locations display menu boards which represent hot beverages that contain 12 ounces for tall, 16 ounces for grande, and 20 fluid ounces for venti. Plaintiffs allege that Starbucks uniformly underfills its lattes to save on the cost of milk. According to plaintiffs, Starbucks made a conscious decision to underfill lattes when faced with financial difficulties and high milk prices at the end of 2007. Plaintiffs further allege that when the lattes are created pursuant to the company's standard recipe, the resulting beverages are underfilled because, 1, the maximum capacity of the cups used to serve hot lattes is exactly the promised beverage volume, and Starbucks does not fill its hot cups to capacity in order to accommodate milk foam, which does not count towards the volume of its lattes. And 3, the standard pitcher currently used by Starbucks baristas to make lattes contains a fill-to line, which results in beverages which contain less than the promised beverage volume. Defendant moves for summary judgment on the grounds that plaintiff cannot prove a false statement or representation based on the undisputed facts. Specifically, the evidence shows that the capacity of the cups is greater than the beverage volume, that milk foam is a component of a latte and counts towards volume, and fill-to lines serve as a guide for baristas when pouring cold milk, which expands in volume as the milk is aerated and heated to serving temperature. We know what summary judgment is, but summary judgment is when there are no material facts that might affect the outcome of the case. It's said as demonstrating the absence of a genuine issue of material fact. So if there's no dispute over the salient, relevant facts in the case, then the court can decide things on summary judgment. And the standard is high. The moving party must affirmatively demonstrate that no reasonable trier could find otherwise. The trier would be the judge in a bench trial or the jury in a jury trial. So remember, we not only have the law, but we have the facts, and the judge determines the law. The jury will determine the facts unless the parties agree to a bench trial. Motion for summary judgment. Defendant asserts that Starbucks is entitled to summary judgment because all 8 of plaintiff's claims require a false or misleading representation, and plaintiffs cannot satisfy this requirement. Plaintiffs agree that each alleged claim has that common element. Plaintiffs seek to satisfy the element based on 3 theories. 1, the capacity of the cups is exactly the promised beverage volume. 2, milk foam does not count towards the beverage volume, and the total volume of the ingredients does not add up to the promised beverage volume. The hot cup theory. Plaintiffs allege that when filled to the brink, hot cups hold exactly the promised beverage volumes. In response, Starbucks offers the declaration of Wendy Luban, a senior manager of quality assurance and food safety for packaging, who testifies that Starbucks requires its suppliers to manufacture the cups with volume capacities which are 8 to 12% greater than the promised beverage volume, depending on the size of beverage ordered. Defendant also provides the Starbucks sourcing toolkit, which specifies the mandatory minimum standard requirements for hot cups, including size, dimension, and weight, and capacity to brim. Plaintiffs challenge Ms. Luban's declaration and supporting documents on the ground that the sourcing toolkit does not purport to measure any actual hot serving cups, but merely conveys manufacturing specifications. However, plaintiffs offer no evidence that any actual hot cups failed to comply with the minimum mandatory standard requirements set forth in defendant's sourcing toolkit. Plaintiffs also offer the expert opinion of Carol T. Hockert, a division chief, National Institutes of Standard and Technology, Office of Weights and Measures. Hockert opines that given Plaintiff Robel's testimony that his grande was underfilled to 1 1/8 inches below the rim, my measurements would indicate an underfilling of approximately 21% relative to the promised beverage volume. Hockert offers a similar opinion, also based on portions of Crittenden's testimony, 14% underfilling. However, plaintiffs gloss over the fact that Hockert's own analysis indicates that the capacity of hot cups is 14.5 fluid ounces for a tall, 18.5 for a grande, and 22.5 for a venti beverage. According to Hocker's findings, the capacity of the hot cups is actually 14 to 21% greater than the promised beverage volume depending on the size of beverage ordered. In other words, plaintiff's own expert corroborates Luban's testimony and contradicts plaintiff's allegation that the hot cups hold exactly the promised beverage volume. In any event, plaintiffs effectively concede that they have insufficient evidence to support this theory by seeking to withdraw it. See the document number 115 at paragraph 2. Therefore, the court grants defendant's motion for summary judgment on plaintiff's first theory. Second theory, milk foam. According to plaintiffs, the foam added to the top of Starbucks lattes does not count towards the volume of its beverages because foam is not measured on a volumetric basis. Plaintiff's argument fails in light of plaintiff's own allegation that milk foam is an ingredient of a latte. In a different case, Furugesh versus Starbucks, plaintiff brought a putative class action alleging that Starbucks defrauded its customers by advertising its cold drinks as containing more liquid than the drinks actually contain. According to the complaint, Starbucks underfilled its cold drinks by adding ice to make the cups appear full. In dismissing the complaint with prejudice, the court highlighted that a reasonable consumer would not be deceived into believing that Starbucks cold drinks contained the promised beverage volume excluding ice, because when a reasonable consumer walks into a Starbucks and orders an iced tea, the consumer knows the size of the cup that the drink will be served in and that a portion of the drink will consist of ice. Further, the court noted that a consumer can increase the amount of beverage if they receive the order with no ice. Just as a reasonable consumer would not be deceived into believing that cold drinks contain the promised beverage volume excluding ice, no reasonable consumer would be deceived into believing that lattes, which are made up of espresso, steamed milk, and milk foam, contained the promised beverage volume excluding milk foam. Neither the menu nor signage plaintiff has reproduced and incorporated into the complaint explicitly state that lattes consist of the identified ounces of liquid. Further, when a reasonable consumer walks into a Starbucks and orders a latte, that consumer knows the size of the cup that the drink will be served in and that a portion of the drink will consist of milk foam. Accordingly, the court has no difficulty concluding that a reasonable consumer would not be deceived into thinking that when they order a latte, the drink they receive will include espresso, steamed milk, milk foam, and some portion of that drink will be milk foam, rather than whatever liquid beverage the consumer ordered. In any event, plaintiffs can increase the amount of liquid beverage if they order a latte with light or no foam. The court thus finds that plaintiff's argument regarding milk foam fails because a reasonable consumer would not be misled into believing that milk foam does not count towards some portion of the volume of their latte. Third theory, fill two lines and beverage recipe cards. Finally, plaintiffs argue that the fill two lines on steaming pitchers used by defendant to make lattes are too low for the finished product to contain the promised beverage volume. Essentially, plaintiffs claim that the quantity of ingredients used in Starbucks standard recipes to make lattes do not add up to the promised beverage volume. According to plaintiffs, Starbucks beverage recipe cards instruct baristas to use quantities of ingredients which do not add up to the promised beverage volume. For example, instructions for a grande latte provide for 11 ounces of cold milk and 2 ounces of espresso topped with 1/4 inch of milk foam and 1/4 inch of extra space. Plaintiffs thus argue that the liquid contents of the grande latte are 3 ounces short. But that theory fails. As an initial matter, as noted, the milk foam must be included when measuring the volume of the latte. Secondly, the complaint defines a latte as a drink made with steamed milk and states that lattes are created by mixing steamed milk and espresso. To the extent that plaintiffs attempt to define a latte as anything other than a coffee drink made with espresso and steamed milk, the attempt is outside the scope of the complaint. Accordingly, the cold milk measurements indicated on Starbucks steaming pitchers fail to raise a triable issue as to underfilling because plaintiff makes no showing that the sum of espresso and steamed milk and milk foam results in lattes which are less than the promised beverage volume. Finally, plaintiffs fail to show that leaving 1/4 inch of extra space when filling hot cups which have maximum capacities which are 1+ ounces greater than the promised beverage volume results in lattes which are less than the promised beverage volume. As discussed above, each of plaintiffs' causes of action requires at a minimum a false statement or misrepresentation. Plaintiffs' failure to establish such a statement or representation is fatal to each of their 8 claims. For the reasons discussed above, the court finds that plaintiffs have failed to raise a triable issue of fact. Therefore, the court grants Starbucks' motion for summary judgment and denies plaintiffs' motion to strike. Defendant shall file a form of judgment approved as to form within 5 business days of the date of this order. It is so ordered. Yvonne Gonzalez Rogers, United States District Court Judge for the, Northern District of California. So that's pretty cool. You know what I learned? Brandon?
What was that?
I learned that I can order my latte with light or no foam, or my iced beverage with little or no ice, and they have to give me the rest of it as they can't short me the beverage then. They can't say, oh well, you took the ice out, you get less beverage. So if I want my iced coffee with, more coffee, I just ask for less ice, and they have to. I didn't know you had to do that.
I do that at every restaurant, not because of the volume thing. It's just like a bonus, but I just don't like ice.